How do you manage an ethical, appropriate relationship between the judiciary and the executive, right? This becomes an important question in the light of the debate around the collegium. How hard could you have pushed? There were certain transfers, for example, that were recommended, or government just sits on the file. There are certain judges recommended, Saurabh Kirpal. File comes back, it's sent back, government sits on the file. There was a very public, vitriolic commentary on the collegium system at a point when we had Mr. Rijiju as law minister questioning the entire collegium system. I'm just wondering, when you look back at your tenure, do you think you pushed as much as you could on the appointment and transfer of judges?
Barkha, you asked me about the relationship between the ethics and the relationship between the government and the judiciary.
And as you know, there was so much commentary when you met with when the Prime Minister met with you for a puja.
There are two aspects. There are two aspects which have to be emphasized. First is the relationship between the court and the government as the largest single litigant in the judicial process. The largest single litigant today in India is the government. Whether it's in terms of, the social welfare laws, labor, tax, just the whole gamut of laws. In the work which judges do, there is absolute independence and a clear difference between the government and the judiciary. Both the government and the judiciary are part of the nation state, but these are two distinct wings of the nation state. Yeah. The executive, the legislature, and the judiciary, the three wings. In the work which courts do, there is an absolute and clear demarcating line between the government and the courts. And the surest test lies in the question which you asked me about the electoral bonds. The courts have taken and continue to take decisions which will go either way, and that is itself a sign of judicial independence. On the administrative side and on appointments, the position is much more nuanced, because both the government and the judiciary are vital stakeholders in the process of appointments. They are vital stakeholders not merely from a public policy perspective, but from the constitutional perspective, and particularly as the Constitution has been interpreted in the judges' cases, where the appointments are routed through the judiciary, but ultimately the government has its own inputs. Now, this is an area where there obviously has to be a dialogue between the government and the judiciary, the Chief Justice of India. I remember in one of your segments when you were interviewing Fali Nariman, was a great mentor to me. I really
great guy.
I miss him. Great person. Yeah. Fali said that, why is the Chief Justice not engaging with the Law Minister? I remember his words in that interview.
I do remember.
And I never went and told Mr. Nariman, because I respected him too much to even, hazard, a conversation with him on this. But, the point of the matter was the Chief Justice was in active engagement with the Law Minister.
Yeah.
And the Chief Justice of India has to be in active engagement with the Law Minister on making appointments. And this is the position both before the collegium system came into operation and post the collegium system coming into operation. There are obviously differences in perspective. And we have to, as mature statespersons, we have to accept the fact that there are differences in perspectives. Now, it is because there may be differences in perspectives that you have to have this dialogue when a file is held up. And during my entire tenure, whether it was Mr. Rijiju or Mr. Arjun Meghwal, I was in constant conversation with the
Law Minister.
With the Law Minister, that you say that, Law Minister, these are the appointments to the High Court. So many appointments now, they're in the pipeline. Something has been held up, say, at the level of the IB. When is this going to be completed? And you're continuously reviewing the work.
But when they continue to just sit on it, what can a judge do?
Well, the judges, the decision in the judge's case mandates that once a name has been reiterated by the collegium, that binds the government.
Right.
Well, that is the position of law. And if certain names have been reiterated by the collegium and appointments have still not been made, that's for the government to explain.
You
So far
can't
as-
summon somebody in the government.
You engage with the government. Summoning is when you sit as a judge.
Yeah.
When you sit as
No,
a
as a
constituent.
judge, is it
when
contempt
you-
of court? I'm just trying to understand the position that if you reiterate the name, which is, I think, what happened with Mr. Kirpal, and then there's no
Yes.
movement, then is the government in contempt of court?
Barkha, I have a different take on this whole issue of contempt jurisdiction. My take is very different. The judiciary, as well as the government, are constitutional stakeholders in the process of judicial appointment. Each of us have an assigned role. The power to exercise the contempt jurisdiction is a power which must be exercised extraordinarily sparingly, particularly in these contexts. For the simple reason that we are a stakeholder in the constitutional sense. We have a vital role in the constitutional sense. If the judiciary uses the power of contempt to get its own way through, there would be some issue on that. Should you be using your judicial power to punish for contempt?
I see what you're saying. Yeah.
To really push through what someone may say your agenda on the administrative constitutional side.
Yeah.
That is one. Second, the better answer in all these cases is to engage in ongoing dialogue, ongoing statesmanship, and virtually by the week, if not by the fortnight, I would be in engagement with the law minister, reviewing vacancies which have to be filled up, reviewing files which are cleared, pushing certain files which have to be cleared because somebody's term as an additional judge is coming to an end. You have to tell the government that, we have to do this quickly because somebody is retiring as an additional judge. Particularly, this happens in the context of the service judges who come into the high courts. So there are a range of issues, some of them which are vexed, others which are more routine. But speaking for myself, we have done one of a couple of things. We have been putting out, at least during my tenure, the reasons for the decisions of the collegium.
Yeah, you made it quite transparent,
And therefore, the reason why we felt that Saurav Kripal's appointment should be made was put up in the public realm.